Classified Crime is on the case of Sarah Boone, and today we're going to continue our family court recap series, starting with the modification that Brian filed in 2022. Okay, if you recall on part 1, we went over the highlighted items here, and then we also looked at Brian's answer to counterclaim, the property settlement, parenting plan, Sarah's answer and waiver of appearance to the final hearing, Sarah's financial affidavit, and the child support guidelines worksheet. We did not look at this final court hearing, but it basically incorporates the property settlement and parenting plan they agreed upon. We'll look at that briefly today. Then there are 2 letters to Sarah from the court that we'll look at. They were just asking for an updated address after she had been rehomed into the Orange County Corrections Department, and they were not able to get in touch with her at her previous address. So we'll look at those 2 items, and then we'll look down here at the original notice of appearance and petition on motion for modification from Brian that he filed on April 12th, 2022, requesting for the modification after she had been incarcerated since 2020. So let's get right into that. And this is the final judgment that was executed and filed on June 15th, 2018 between Sarah and Brian. I'm going to briefly go over this. Basically, it came before the court on June 15th, 2018. The husband's petition for dissolution, the wife's amended answer, waiver, dismissal of counter petition. And the court reviewed the pleadings and has ruled that they do have jurisdiction, that the marriage is irretrievably broken. The marital settlement agreement and parenting plan, the parties executed these 2 things on May 3rd, 2018, Exhibits 1 and 2. The court finds that the marital settlement agreement and parenting plan were executed freely and voluntarily by the parties after full disclosure. Accordingly, the marital settlement agreement and parenting plan are approved and incorporated herein by reference, and the parties are ordered to so comply with the terms contained therein. There is a minor child born in 2010 the court has jurisdiction over, and they did use the Uniform Child Custody Jurisdiction Enforcement Act. There are no other children expected. The parties shall exercise shared parental responsibility for the minor child in accordance with the terms of the parenting plan. As and for a contribution towards the support of the minor child, the husband shall pay to the wife the sum of $100 per month beginning July 1st, 2018. Payment shall be made through the state of Florida disbursement unit until terminated by court order, agreement between the parties, or upon the child reaching the age of 18, whichever shall occur first. And it shows where to mail the payments, adding a fee, and how to pay. And the parties shall inform the SDU immediately of any change of name, mailing, or address, or change in any other circumstances that may affect their ability to discharge its duties under law or send or receive the payments from them. This is going to apply momentarily when we look at the letters they sent to Sarah in 2021. In the event the minor child is a full-time high school student, upon reaching his 18th birthday, the obligation for support shall continue through the end of that school year, but not later than his 19th birthday. Upon the minor child reaching the age of 18 and graduating from high school, the child support obligation shall cease without further order from the court. They have the medical insurance and expenses. The husband will include the minor child in his medical and hospital insurance policy and is responsible for premiums. Durational alimony beginning May 1st, 2018 and continuing on the first day of each month thereafter. The husband shall pay the wife the sum of $1,000 per month and as in for durational alimony. Said payment shall be made by direct deposit from the husband's bank account to the account the wife shall designate. Upon the death of either party, the wife's remarriage, or after 84 payments have been made, whichever shall occur first, the obligation to make further payments shall cease except for any arrears. So this is kind of what they're looking at tomorrow in court. He has arrears according to the order, according to how it's ordered here. But this sentence is why Brian filed the modification. The alimony amount is modifiable upon a showing of a substantial change in circumstances, but the duration cannot be exceeded for any reason. Now, looking back here, except for any arrears. So that's what they're going to mostly be looking at tomorrow. Brian filed the modification because as you look here in the order, it is modifiable upon showing a substantial change in circumstances. For example, someone taking the life of someone else and becoming incarcerated is a substantial change in circumstances because now the income documentation they've both submitted has changed significantly for at least one of them. The parenting responsibility has changed for both of them. So there is a substantial change in circumstances. The duration cannot be extended for any reason. This is the court order, except for any arrears. So what they're going to be looking at is the arrears. However, Brian filed this modification. We're going to look at in 2022, and the court will look at what they said, but this is what they're looking at tomorrow. A big part is this right here. And this sentence, these two sentences are going to be examined by the judge. Okay. The alimony payment shall be included as income to the wife and deductible by the husband for income tax purposes as long as the alimony continues to be paid. That means as long as he was paying her the alimony, she was supposed to be filing a tax return. In the event of a modification of the amount of the alimony payment shall be based on the tax law in effect prior to this tax law, which I don't know anything about or we probably don't care about. It's not relevant now. And then they divided the marital property. The husband was awarded sole possession, use, and ownership. The wife executed a quitclaim deed conveying all of her interests in the real property, except for what he was supposed to pay her in the settlement agreement. The final judgment shall have the effect of a duly executed instruments of conveyance when recorded in the public records of Orange County. The court specifically reserves jurisdiction over the parties, the minor child, and the subject matter of these proceedings to enter such other and further orders as it deems just and proper, ordered the 15th day of June. So that's basically the final order. And then, of course, the two exhibits, 1 and 2, the parenting plan and the settlement agreement we looked at in part 1. So here we just went over the court hearing final judgment, and now we're going to look at these two letters. Okay, this shows on December 17th, filed in the court's office, the letter that they mailed out to Sarah Boone at her apartment, the France court apartment. It says, our records indicate that the clerk of court does not have a correct address for you on file and is unable to send child support payments to you. Money may have been sent but was returned or may be on hold because your address is not current. In accordance with Florida statutes, parties using the depository for support payments, which if you remember the court order, they use it, shall inform the depository of changes in their name or address. Notification of all changes shall be made in writing to the depository within 7 days of a change. As of 12/17/2021, the clerk of court has not been able to disperse funds to you for the above case. It is very important that the clerk of court have the current address for you on file to ensure support payments are processed in a timely manner. Florida state law requires funds that have not been claimed after 12 months to be sent to the state of Florida as unclaimed property. To prevent your funds from being sent to the Florida Unclaimed Property Office, please contact the clerk of court listed below to update your address. And then it has where they contact. So that means after she was incarcerated in February 2020, there were still child support payments in her account that could not be dispersed. And she needed to update her address. Now, I don't know if they could disperse them to her in the jail or not. But according to Florida law, after 12 months, if the property is still remain unclaimed, it would be sent to the state of Florida as unclaimed property that you would have to look up and figure out how to claim as your property. And then they sent this letter out to her again. So let's take a look at the second one. And this letter was filed on April 12th, 2021. So they sent one out in April and then again in December. Says basically the same thing, that they do not have a correct address on file. They're unable to send payments. Money may have been returned. That you were supposed to update change of address within 7 days. And they will send it to state of Florida as unclaimed property if you don't claim it within 12 months. So just 2 times they sent the same letter out to her, once in April, once in December. Okay, so we've looked at both of these letters. And now we are at the petition for motion on modification from Brian on 4/12/2022. Okay, so this is filed 4/12/2022. Brian, petitioner, and Sarah, respondent. This is a supplemental petition for modification of the final judgment. The former husband, Brian C. Boone, individually and by and through his undersigned attorney, hereby files this petition for modification of final judgment of dissolution of marriage dated June 15th, 2018, and states as follows. 1. Action for modification. This is an action for modification of the final judgment entered by this court on June 15th, 2018. The final judgment incorporated the marital settlement agreement and parenting plan, both executed on May 3rd, 2018. A copy of the final judgment is attached hereto as Exhibit A. 2. Jurisdiction and venue. Pursuant to paragraph 10 of the final judgment, this court retained jurisdiction over the parties, the minor child, and the subject matter of these proceedings. Venue is proper in Orange County, Florida, as both parties and the minor child reside in Orange County. Substantial change in circumstances. Number 3, since the entry of the final judgment, there have been material and substantial changes in circumstances that require a modification to the parenting plan, marital settlement agreement, and final judgment, including but not limited to the following. A. On February 25th, 2020, the former wife was arrested and charged with second-degree M of her boyfriend after she locked him in a suitcase. The former wife was committed to the custody of the sheriff of Orange County and has been held without bail in the Orange County Jail since February 25th, 2020. The parties have one minor child born in 2010. The minor child has lived exclusively with the former husband since the former wife's incarceration and lived the vast majority of the time with the former husband since the parties' separation on September 11th, 2017. Inasmuch as the former wife is in jail, she does not have the financial need for alimony or child support payments at this time. The former husband has voluntarily deposited money into the former wife's inmate account so that she may purchase items from the inmate commissary. Modification of shared parenting. Due to the former wife's lack of proper judgment as described above, and because of her behaviors in front of the minor child prior to her incarceration, it is in the minor child's best interest for the former husband to be awarded sole parental responsibility, decision-making, and 100% time-sharing. The former wife does not have the mental or physical ability to co-parent at this time, nor can she exercise any time sharing. Termination of alimony. Paragraph 4 of the final judgment requires the former husband to pay durational alimony to the former wife in the sum of $1,000 per month for a period of 84 months. The former wife does not have the financial need for alimony at this time and will not throughout the period of the durational alimony, which, if not earlier terminated or modified, would end with the payment due on April 1st, 2025. Also, due to the former wife's admitted egregious behavior of locking her live-in boyfriend in a suitcase, which ultimately led to she is not entitled to alimony. The termination of the durational alimony should be retroactive to February 25th, 2020, the day of the former wife's arrest and incarceration. In the alternative, the former husband requests that the alimony be reduced or at least suspended for the period of time that the former wife is incarcerated. Termination of child support. Paragraph 6 of the final judgment requires the former husband to pay the former wife the sum of $100 per month towards the support of the minor child based on the equal time sharing schedule outlined in the parenting plan on the financial abilities of the parties at that time. Since February 25th, 2020, the minor child has lived exclusively with the former husband, who is responsible for 100% of his financial needs. The former wife does not incur any expenses for the minor child, and as such is not entitled to child support or designating money that she can determine how to spend on the child as child support. The termination of child support should be retroactive to February 25th, 2020. Now, notice the attorney does put the amount of money written out and in parentheses numerically, but not each number. Okay? When he's just referring to a number, like paragraph 4. Okay, he did put monetary amounts, but every single number in here is not also in parentheses numerically. Just pointing that out. Okay, attorney's fees and costs. The former husband attempted to come to a resolution of these issues with the former wife without the necessity of filing a contested supplemental petition for modification, and requested that the undersigned attorney prepare a joint stipulation. The former wife would not sign the joint stipulation, which resulted in the filing of this action. So, cause, effect. She wouldn't sign. It resulted in the filing of this action. And we're about to look at a letter that she wrote responding to this, and she is acting like it came out of left field. The former wife should bear the responsibility of the former husband's attorney's fees as her actions and her failure to act necessitated the attorney's fees. Wherefore, the former husband urges this court to modify the final judgment and grant the following relief. Award the sole care and custody of the minor child to the former husband, as well as 100% time sharing and decision making, which is already happening anyway. Terminate the former husband's alimony obligation to the former wife, retroactive to February 25th, 2020, or in the alternative, suspend all payments during the former wife's incarceration. So he's saying, like, pause it at February 25th, 2020, and until and if she were to be released, suspend them. Terminate the former husband's child support obligation, retroactive to February 25th, 2020. Order the former wife to pay the former husband's reasonable attorney's fees and costs as necessitated by her actions, and order such other relief as this court deems proper. This was dated the 18th day of February 2022, but it was filed on April 12th, 2022. And it gives a certificate of service via process to Sarah K. Boone on the date and time as detailed in the acceptance affidavit of service to be filed herein. Well, let's take a look at that. And this is the summons that he served to Sarah. It was filed 4/12/2022. And this is a personal service on an individual. It's in 3 languages here. So that is just to be aware of that. So to Sarah K. Boone, Orange County Jail, important. A lawsuit has been filed against you. You have 20 calendar days after this summons is served on you to file a written response to the attached petition with clerk of this circuit court. And it lists the address. A phone call will not protect you. Your written response, including the case number given above and the names of the parties, must be filed if you want the court to hear your side of the case. If you do not file your response on time, you may lose the case and your wages, money, and property may be taken thereafter without further warning from the court. There are other legal requirements. You may want to call an attorney right away. If you do not know an attorney, you may call an attorney referral service or legal aid office listed in the phone book. If you choose to file a written response yourself, at the same time you file your written response to the court, you must also mail or take a copy of your written response to the attorney for petitioner named below. Copies of all court documents in this case, including orders, are available at the Clerk of Circuit Court's office. You may review these documents upon request. You must keep the Clerk of Circuit Court's office notified of your current address. You may file notice of current address, Florida Supreme Court approved, Family Law Form 12.915. Future papers in this lawsuit will be mailed to the address on record at the clerk's office. Warning, Florida Family Law Rules of Procedure requires certain automatic disclosure of documents and information. Failure to comply can result in sanctions, including dismissal or strikings of pleadings. And then they have it in Spanish and French. And then it has the attorney and the clerk. This is the certificate of affidavit of service filed for 4/28/2022 for the Josh Martell family law. And this is the process server. It said received by Alliance Process Inc. on the 21st day of April 2022 at 11:19 a.m. to be served on Sarah K. Boone at the Orange County Jail in Orlando, Florida. I, Anthony Liu, being duly sworn, depose and say that on the 22nd day of August, April 2022 at 9:55 a.m., I, individual personally served by delivering a true copy of the summons, supplemental petition for modification of final judgment, joint stipulation for modification, Uniform Child Custody Jurisdiction and Enforcement Act affidavit, notice of appearance of counsel, and designation of primary and secondary email addresses, letter to Sarah K. Boone at the address of the Orange County Jail, Orlando, Florida, with the date and hour of service endorsed thereon by me and informed said person of the contents therein in compliance with state statutes. And it's signed and notarized here. Okay, so we've looked at the summons and the certificate of service. And now, May 16th, we're going to look at Sarah's answer to motion for modification. This is her first family court letter, and it's dated May 1st that she wrote the letter. Okay, and this is her response filed in the court's office, clerk of court, 5/16/2022, written by her 5/1/2022. She addressed it to the Marriage Division of Orange County Courthouse in Orlando, Florida, in regards to the marriage of Brian C. Boone, Sarah K. Boone, and the case number here. And it says, Dear Sir and Madam, I am writing in regards to a summons I received on April 22nd, 2022, stating a lawsuit has been filed against me in the aforementioned matter. As instructed, this letter will serve as my personal/individual written response to the supplemental petition, joint stipulation, and notice of appearance included. I am in the process of trying to obtain representation for this and diligently working day by day, doing the best I can, and am literally able with the little to non-existent resources I have available. So here she goes with the beginning of a sob story when this is just supposed to serve as a written notice that she is responding. It's no one reading this is like going to swoop in and take action or anything, but she's starting her sob story here. So, non-existent resources. Please know with great emphasis that I am doing everything possible to defend and protect myself as a person and a mother foremost while incarcerated temporarily. Yeah. I have nothing and no one to help me as both my parents, grandparents, aunt, and uncle are deceased. I have an older brother who is unable to be located and a younger brother who is currently deployed in Africa for the Marines. I also have no counsel of any kind. Per the summons packet, I have tried to contact a referral service and legal aid via phone with no success due to the numbers being unauthorized in accordance to the rules of Orange County Corrections Department. I am working expeditiously to find an alternative way to contact and figure out some type of facilitator in the meantime. Your patience is greatly appreciated. As said, I am doing all I can to stress my dedication as well as seriousness to this matter as a concerned parent and how it is of the utmost importance to be rightfully conveyed and understood as the very competent, caring, loving, hardworking, determined person that I am and whose mental ability to co-parent is undeniably obvious and without any doubt should be included in the ongoing nurturing of our son. So she's answering Brian's questioning her fitness to be a co-parent in the summons she received. She's not providing any evidence of her abilities. She's just listing them out. Again, she's just talking about how she feels, what her opinions are. She's not talking about any facts, dates, times, anything like that so far. Okay. My decisions, ideas, opinions, feedback, rules matter. To be excluded in any way just because of my current temporary circumstances and location is wrong, unfair, and unacceptable. It makes absolutely no difference where I am. Jail, space, Australia. Okay, why are you being dramatic? It's like at this point, she's just ranting. This is supposed to be an answer, a professional answer. Did the attorney for Brian list a bunch of dramatic theatrics in the petition for modification? No, they just stated actual facts. This is arduous and unnecessary. I am not and will never be useless, especially to our son. No one said that. So why did she bring that up? I am still his one and only mother who loves, cares, and adores him beyond measure and make his safety, mental, emotional, physical, and spiritual well-being my priority and will for the rest of my life. Okay. Were you making him a priority when you made the decision that you made that got you here? You weren't thinking about him. You were drunk out of your mind. You took someone's life. That affects your life, liberty, and the pursuit of happiness abilities because they are now restricted by the state of Florida because of your actions, not because they just knocked on your door and yanked you out of your house. I will never stop being his mother and using the God-given talent and rights as his mother to remain so. One obscure, unfortunate incident does not define me as a person or my entire existence. It kind of does. It kind of does. Like any person on the Department of Corrections, like when we looked up her little, when you look up inmates, it just has their picture, their charges, their sentence, like their date of birth, like that. It boils you down to that. Unfortunately, for you, all the other things you've done, nobody's focused on that anymore. All they can think about is how could you have done that? Okay. I want my son to know and show him I am always willing to exceed any limitations placed upon me, even by yourself, that would hinder my relationship with him as his mother and being included in every aspect of his life, then, now, and future. He is my life. Who is former husband, quote unquote. So here's the onset of the quote unquote husband. Okay. You already wrote it right here. Former. So the quote unquote is not necessary. He's not your husband. You wrote it right here. Former. He's not your husband. So you don't need to put in quotation marks. Okay. Who is former husband to assume and think? Okay. So now thinking is in quotation marks. His sole decisions are the best, fairest, and most successful for our son. I have God, my giving heart, functioning well above average brain. Girl, no. No. If it was well above average, you wouldn't have been writing this and submitting it. And bold voice, that she does have, to be my son's best advocate as well as my own. I matter. Keep telling yourself that, babes. All right, so I want to go back to think his sole decisions are best, fairest, and most successful for our son. He probably thinks that because he's the parent that's not incarcerated and has the actual ability to care for the child. You are at the mercy of the court, the Orange County Department of Corrections. You don't know this yet, but later on, Lowell Correctional Institution. So you're at the mercy of them to allow what they will and will not allow you to do in quote unquote parenting your son. So that is why he quote unquote thinks that. And I'm pretty sure he knows that. If needed, our son should be included and asked his thoughts of his father attempting to remove my right in being his mother, and only ever able to ask about his video games and what he had for dinner. Nothing of moral value or life defining. Yeah, because your moral compass and your character have been called into question by the Orange County court. And you are now in the Orange County Department of Corrections. So you're not allowed to like morally guide him anymore. I find that totally reasonable. Also, if you want to include your son, who at this time, this is 2022, and the son was born in 2010. So he's between 11 and 12 years old. You want him to be included and ask his thoughts about what his father is doing in family court. That is exactly what the parenting plan says you should not do. You are not to use the child as a pawn to relay messages back and forth to mom and dad. You're not to put them in the middle of the court proceedings. Okay. You're just supposed to ask him about video games and what he had for dinner. Yeah, that's what you talk to children about. No one wants you to talk to him about anything life-defining. What life-defining decisions have you made that you can guide him in? I mean, I'm pretty sure like if a teacher sent home a field trip permission form and said, hey, I'm going to take this class of 4th, 5th graders down to the Orange County Department of Corrections so they can, choose an inmate to interview and ask them, how they made the decisions they did in order to get here in life. No one would sign that form because they don't want their children to turn out like that. So that's why you're not allowed to do anything of moral value that is life defining. Okay. Because you're an inmate. That's not something that people generally look at as a great example for what children should aspire to become. And I'm sure a family court judge would feel the same. I am not the worthless, mindless, heartless, unproductive, non-contributing, poor, and pitiful footstool he would like me to be and tries to make me out as to others. So you're saying are you interchanging your son and Brian with that pronoun, or who are you talking about? You're just going back and forth. So heartless, your actions were heartless. Mindless, you were drunk out of your mind. unproductive, you're not working now, you weren't working then. Non-contributing, you're basically just sucking up resources and time. Poor and pitiful, check and check. All right. It makes no difference where I am. It's who I am, his mother, now and always. And again, one incident does not define me or my entire existence. Keep telling yourself that. I have so much to offer in so many ways, and it would be extremely detrimental as well as a great loss to not be able to continue in the shaping of our son and his very extraordinary life. Is former husband able to handle the consequences, burden, and heartache should his decisions jeopardize or harm the best possible outcomes and inhibit the absolute success our son could have been or had? Well, he doesn't have a choice because he is a single parent now of no fault of his own. So any parent making decisions has to handle the consequences, burden, and heartache of their decisions down the road. That's part of being a parent, kind of like how you have to do that now. You have to handle the consequences of your decision because your decision jeopardized or harmed the best possible outcome for your son. But you're not interested in anyone pointing that out. We only want to point at the person raising the child because they had no other choice. They had no other choice. You were taken to jail. Brian had to raise your child. So yes, he has to make the best possible decisions with or without you because you're not there. How will this sole great responsibility, should it be awarded, affect the former husband's mental ability going forward, as all instances, scenarios, and situations are not the same? That is why there is two parents, both to broaden all horizons, outlooks, and futures for their children, and in which I am so desperately fighting now to continue to do for mine, and all for the right reasons. Again, yes, but people don't generally look at inmates to help broaden horizons and futures for their children. Like, that's not, most people would agree. I am no longer going to willingly make it easy for former husband to advantageously rob me of my last and only my new life resources out of bitterness, greed, and spiteful opportunity. At my weakest, broken, most vulnerable moments, he is attempting to take full advantage of such with this unwarranted, vicious attack, thinking, hoping, and assuming I will wave a white flag, which I do not own. Oh, we know that. Especially when it comes to my son. Now, wait a minute. So this is bitterness, greed, spiteful, vicious. I'm sorry, didn't the final court order and the parenting plan say that it wouldn't be modified unless there was a substantial change in circumstances? I mean, even you have to admit you've had a substantial change in your circumstances. I don't know what else you would call it. Okay, he is wrong in doing so, knowing fully the playing field is not and has never been even. Why? Why hasn't it ever been even? Again, no facts, no dates, no times, no receipts. All odds are against me due to my monetary restrictions and lack of a support system. It is illogical and futile to try and have a conversation or discussion that is real, rational, or legitimate with former husband about anything then, during our marriage, and now. His superiority complex and ongoing dishonesty have made it very difficult and sometimes impossible to work with him. This in turn has compelled me now to bring attention some of my concerns in the egregious, why is that in quote unquote? Are you saying the decisions are egregious, or are you saying they're not? Quote unquote egregious decisions he has made prior and during my incarceration, as well as from my son, personally stating dad's laziness, empty promises, and disappointments. In regards to what? Kids get mad when parents make boundaries. And I don't know a lot of kids that use the phrase empty promises. The child knows without any hesitation or doubt, I will do anything, anytime, anywhere, all within reason to help him, which is why I, his mother, have been his go-to person in many ways for many things throughout his life, including while being incarcerated. Former husband is penalizing me because I care nonstop and have regular ongoing concerns/questions as our son continues to grow that are important, needing to be discussed. Our son can and will grow better, stronger, brighter with my decisions included, also as they have been since I brought him into the world. Former husband and I did this together, and I may be obsolete to him, but I am not to my son, nor will I ever be. So stop trying. This letter is to the court, not to Brian. Or did you forget that? When trying to speak to or with former husband and have an opinion, idea, belief, feedback, etc., that is not in line with his or his parents, I have been laughed at, completely ignored and disregarded, given the silent treatment, berated, and made to cry, or hung up on, most every time in front of our son. This to me is setting a poor example of how a man, husband, should treat a woman, wife, on top of being a bully. The child hears and sees how former husband, his father, treats, degrades, and judges me, his mother. This is extremely confusing and sad to our son, as he knows I only discuss or try to anything that pertains to him. Except up here when you said that they should ask him how he feels about how his dad is treating you. But that's contradicting yourself. He hears me being told indirectly I am unimportant. This is unacceptable, damaging, and mean, also having lasting effects. An inherited trait led by example of his father and serves no purpose, quality, or value. A bad decision. Okay, it is true that if, of course, this is from Sarah's point of view, if she is being made fun of or damaging things are being said, that's not appropriate in front of the child. However, saying it is a bad decision is laughable because you don't have the barometer of what is a bad decision anymore. It's like your meter is, very flawed and skewed, because you remember the letter she wrote about 3-point back. Every time you point a finger at someone, 3-point back. What 3 are pointing at you for your bad decisions? All right. What former husband is trying to do is sweep me in a dark, bleak corner and keep me there, hoping I find no way out. No, the state of Florida is trying to do that. He had nothing to do with you going into the dark, bleak cell that you're in. Your actions caused the state of Florida to investigate and put you there. Again, being very dramatic. The relief he is seeking means to remove any additional work, trouble, effort, concern, responsibility, etc., which would make former husband be the reliable, caring, consistent, honest person he should be, how especially to our son, and who I always wanted and needed him to be when we were married, possibly altering the current situation for everyone. Whoa. So you're saying if Brian had been a different person, none of this might have happened? That is a huge stretch of imagination. If I have no authority, power, or control, which is what you really are focused on, there are no discussions or interactions or concerns, ideas, plans, future our son does and will need involving both parents, me, the other parent included. If I have no authority, there are no discussions. So what is she trying to say here? If she has no authority, there are no discussions or interactions of concerns our son does and will need. I'm not understanding the sentence structure. Like, what is she trying to communicate there? You guys tell me. Not only am I continuously disrespected, I am verbally threatened with some form of this looming lawsuit. No, saying that you guys have an upcoming court case is not a threat. He served you properly with the paperwork. It's not a verbal threat. It's just saying this is happening. In former husband's original verbal threat made sometime last year, early 2021, to take away my parental rights and funds necessary for my livelihood while incarcerated. It's funny she put that in quotation marks too. After my sincere, heartfelt begging while sobbing to him while on the phone in the middle of my dorm, in my desperation, asked why he was doing this to me. Why are you doing this to me? Why are you doing this? You mean like how you said that to George while he was zipped up in a suitcase trying to get out? Why was he doing that to you? Probably because it's in his and the child's best interest. And your best interest is not the primary focus anymore. Accept that. Know that. Okay, sorry. Middle sentence rant. In my desperation, asked why he was doing this to me, fully and completely knowing I have nothing or no one and how meaningful it is to me to be called child's mother. His response was simply, I will make you say yes now. If you keep doing as you have been, everything will be fine. I have been saying yes as I've had no choice if I'm even asked anything to be able to answer. I am unclear as usual when dealing with former husband of his behavior with these new revised threats and demands that I have not already submitted to, previously seen, or even knew existed until now being served. Well, that's not what the petition for modification said. The petition for modification said that they gave you a paper to sign and you refused to sign it. So they had no choice but to file for the modification. So you allegedly did get offered to sign a paper and you refused. And that's why they're also asking for the legal fees, because you refused to sign the paper and force it into the court. So I will not be erased or downgraded to nothing because former husband is bored and bitter. I doubt he's bored because he has to constantly 100% take care of a child all the time. He probably doesn't have time to think about all of that, and he's trying to just move forward. Totally unfair, and the cruel ego trip is disgusting and nothing to be proud of. What is the point? There is nothing left other than my dignity, which he'll never have. What would our son say? How would he feel knowing the truth? Again, inserting the child into the legal modification, into the legal battle between the parents. You are not supposed to do that. As you are saying this, the husband shouldn't be talking about you in front of the son. And now you're asserting that the court, ask your son what he would say. Please know, I do still have numerous other legitimate concerns needing to be addressed in the petition and personally, and should be by any decent parent respondent. This is not a one-sided attack and await the opportunity to clarify my specifics if and when needed. I, the mother to our son, believe said concerns are very important. So why don't you list them in this legal response, as that is what you should be doing? You could have consolidated all of this to say, the father is verbally discussing court matters in front of the child and speaking negatively of the mother, and this should be addressed in court. That could have been the end of that. But you inserting all of your emotions once again into legal filings and documents is exhausting to the court. They don't want to know. They don't want to have to go through every text message or phone call or conversation you've ever had. Get to the point, tell them the issue so they can hear both sides and move on. It doesn't need to be a drawn out thing. The court has many other things to deal with. All right. I've realized also this lawsuit, quote unquote, may be my only opportunity due to my restricted resources to have them handled and hopefully remedied professionally, positively, and fairly. I am praying I can be heard, seen, and included by this letter in the ongoing proceedings, meetings, discussions, etc. Futuristically, her favorite word. I am hoping also to have some type of representation to amicably bring this matter to a concrete conclusion, being beneficial to everyone. A copy of this letter is also being sent to legal aid for review and assistance. In the meantime, I am still mom with my mom rights. You sent a copy of this letter to legal aid? And that's why they did not help you. That is exactly why. If they read this letter, they're like, yeah, we're not touching this with a 10-foot pole. All right. The level of this lawsuit is unfair, unnecessary, and uncalled for. This lawsuit is also from one monotone side of former husband. Yeah, that's why you have the opportunity to write in and tell your side, which you are doing. So now there are two sides. Side of former husband. I, the former wife, have a side also. Intellectual, willful, and valuable. That's debatable. Deserving to be heard. I am also fully dedicated and devoted to my son and his rights. His uninfluenced feedback should be included. So again, this is the third time she's saying her son's feedback as an 11, 12-year-old should be included in this court proceeding. And it is only fair to him to know the extent of the situation. Okay, so not just should you ask him what he thinks about, like, whatever, parenting, whatever, the extent of the situation and the cruel attempts of his father to his mother. You want him to know that. That is inserting him in the middle of an argument, which is considered child abuse according to the parenting plan and according to the parenting class you had to complete in order to file for divorce. There's a certificate uploaded for both parents that you completed it, so you are aware of that. No one can tell the future or assume to. I was unaware former husband had a crystal ball. Why? See, you just get so off track. I have faith and will always, this being something no one can take from me, even no one ever. No one can take from me ever. No one either is better than anyone in this or ever. All I can hear her say is, this is forever. And money can't buy everything, especially love, grace, understanding, and goodness. Okay. Well, you're very focused on money. If former husband is willing to have a rational, reasonable discussion, however mediated, I am more than willing and welcome. If there is anything else I can do to show my very good intentions other than writing this letter, expressing my desperation to continue to be included in my son's life, my understanding of the emergent need of counsel, and sheer hope of a resolution. What? So the sentence is starting here and ending here. Here's the start. If there is anything else I can do, my understanding, I don't understand that sentence at all. I am also willing to submit to a competency test or any kind of test to show my capabilities mentally and full ability to co-parent. Full ability would mean like you were able to leave at will, pick up your child, take him to activities, make dinner. You can't do that in your current position. I am not the ridiculous, ruthless, degenerate felon, but you are a felon. You are charged with a felony. You haven't been convicted yet, but that's just a matter of semantics. Former husband slanderously assumes I am. No, it's not an assumption. You are charged with it. If you haven't seen my video where she was in court with the deputy when she filed her motion to be uncuffed, this is kind of the exact same conversation she had with him, because he said she had been charged with the violent crime before, and she kept saying, I was never charged with it. What she means was she was never convicted of it, but because the charges were dropped, but the officer kept saying that doesn't mean it didn't happen. You were charged with it. So it's not an assumption. There are charges on file, on your record. I love my son immeasurable and have a limitless abundance of positive, meaningful, solid, contributing life characteristics to share and have my son inherit from me, which is priceless. I'm not even going to comment. I can co-parent. I want to co-parent, especially if former husband is going to positively participate and understand rather than pillage and point fingers. A mother is her son's first love, in which I very much and with every fiber of my being want to still be. Thank you for your time in reviewing my formal written response in part to the petition. Why is it in part? Just you used 8 pages or 4 pages front and back that you numbered. You could have said everything you needed to say. To the petition, I am grateful for your understanding and hearing my side also, which is only fair and right to do. This is between both parents. Yes, that is why you had the opportunity to file your side. I await your response and instruction. Please do not hesitate to let me know if anything further in my ongoing unreserved cooperation is needed. I am still in this, still a person when former husband was married to for 13 whom former husband was married to for 13 years and has known for more than 20. Most of all, I am still the mother of our son and still important in everything pertaining to him, come what may. Sincerely, Sarah Boone. And here's the envelope where she sent it from the Orlando County Jail. Okay, this was filed July 26, 2022, and it is a motion to dispense of mediation. Comes now the petitioner Brian C. Boone by and through his undersigned attorney, who files this motion to dispense of mediation and in support thereof states as follows. On or about April 12, 2022, the petitioner filed a supplemental petition seeking to modify time sharing, parental responsibility, alimony, and child support due to the respondent being arrested, charged, and incarcerated for second-degree M. The undersigned has attempted to coordinate a mediation with the respondent, but the respondent is refusing to coordinate a mediation at this time. So Brian claims she would not coordinate a mediation. 3, given the circumstances of this case and the petitioner's desire to move the case forward within a reasonable time frame, not drag it out for ongoing 5 years like the criminal case was, the petitioner is requesting that the court dispense of its mediation requirement and allow the petitioner to notice the case for trial. Wherefore, in view of the foregoing, the petitioner, Brian C. Boone, respectfully requests that this court enter an order dispensing of the mediation requirement. And here's a certificate of service that they mailed a copy to the pro se respondent, Sarah K. Boone, at the Orange County Jail on the 26th of July. And this is Sarah's response to the motion to dispense with mediation or the request for it. Sarah wrote this on July 17th. It was filed July 28th, 2022, and it's directed towards Josh Martell of the Martell Family Law Group in Orlando, Florida, in regards to the civil case. Mr. Martell, I am in receipt of your letter requesting a date to be set for former husband's petition to modify, but I have a few concerns and questions before doing so. So he sends you a letter requesting a date. That's it. And this is what he gets back. So just keep that in mind when we look at the next motion, the next document. First, I would like to make it known I have been diagnosed with cancer and am awaiting outside professional medical consult and treatment options. I do not know the level of severity, duration of time, or outcome of any of this, nor the effect it will have on my case, which I am currently incarcerated for, or the case at hand with former husband. As said in my previous letter, no one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from, which you have proposed. With that being said, my concerns/questions are as follows. 1. What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify? So here you're asking him to give you legal advice, which is a conflict of interest because he's representing the other party in this matter. Please provide documentation so I can understand the practices, procedures, and protocols for this area of family law and can abide accordingly. So providing documentation means billable hours. If he's explaining things to you, providing documentation, that's billable hours, and he doesn't work for you. You haven't hired him. I can also have a general timeline of what to expect if possible, other than a letter from your firm telling me what I have to do. So this is her real problem. She doesn't want to take him at his word, but then she also wants him to be the one to explain to her the legal basis of the grounds for his motion. Okay. 2, please provide copies of all documents. Okay, provide copies is billable hours. He's not going to do that because he does not work for you. Of all documents to be discussed, which includes original marriage paperwork, pre-modifications to see and compare specifically what is being requested to be modified. It was in the modification order, specifically what they want to modify, the parenting time, the parenting plan. She's saying, provide me copies of all the originals. That's billable hours. 3, please send contact information, location, and credentials of the selected mediator, Karen Middlecoff, Esquire, and what is her affiliation with the Martell firm and how was she selected? So now you want a whole background history on the mediator selected, even though you're complaining about your very limited resources and you can't even call legal aid. So how would you be able to have selected one either? Now she is questioning the judge credential. Will former husband be in attendance? Who all will be included in and during this meeting? Well, if you're having mediation, both parties have to be present. I'm pretty sure. I am not a lawyer. I am not a professional. Just a nosy lady reading court documents. Number 5, who is the judge overseeing this case and receiving copies of all correspondence, signing, approving paper? Who is this judge? Okay, it's the one that was assigned. He's credentialed to work in Orange County. The HR department has vetted his experience. Like, this is not something that the opposing party's lawyer has to provide you with. 6, is there going to be an agenda for discussion during the meeting to be received in advance for preparation and review? Again, making documents, provide them to me, even though I'm paying you zero, zilch, nada. She wants him to work for her. 7, what if selected date has to be changed due to unforeseen complications or circumstances? We'll cross that bridge when you come to it then. Will I be penalized, rescheduled? Is the point of this mediation to try to force me into signing and agreeing to the only terms available presented by former husband, or are my modifications going to be allowed for discussion also in order for both parties to be included in the final agreements for and with the best possible outcome? So that's what mediation is. Going back and forth and compromising until you come to an agreement. 9, what if I do not agree? Well, it sounds like you already aren't going to agree. And that means it goes to trial. But again, he cannot provide you with the legal advice to these questions you're asking. 10, how is a video conference scheduled? Will this be a private meeting? Is face-to-face an option? She always wants the face-to-face. Everybody make an extraordinary effort to come through the metal detectors at the jail, get searched, come to schedule time with me so we can sit in this dreary, bleak place and I can trot along with my little manila folder and my pen and harass you. As said, I do not know what date is best for me, considering my current situations and now health complications. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. Your expedited response, of course, do it as quickly as you possibly can, is greatly appreciated, as well as providing all requested documents and information. That is providing you with legal advice, which he is not allowed to do. You highly intelligent alien being form, whatever. Thank you in advance for your assistance, patience, and cooperation. He's not going to assist you. I am continuing my pursuit of seeking representation and still doing everything I can with the minute amount of resources I have available. I am not giving up in any way. So again, thank you and all who are involved for your patience. I look forward to your response. Sincerely, Sarah Boone. And here's the envelope that she mailed from a correctional facility. All right, and then this was filed August 11th, 2022. On order on motion to dispense of mediation filed on July 26th. And it says this matter having come before the court on the petitioner's motion to dispense of mediation filed on July 26, 2022, and the court having reviewed the file and being otherwise fully advised in the premises is hereby ordered and adjudged the motion is granted. Either party may move forward noticing the case for trial. This court retains jurisdiction over the parties in the subject matter of this case, done and ordered in chambers in Orlando, Orange County, Florida on the 11th day of August, 2022. And this is Judge Michael Dean. And then it just has the certificate of service to Brian's representation and Sarah Boone at the jail. This was filed 8/22/2022. In the Orange County Courthouse. It is an order setting a hearing. This matter came before the court, and the court, after reviewing the file and being otherwise informed in the premises, it is hereby ordered and adjudged as follows. The case is scheduled for a hearing on Case Management Conference on September 19th, 2022 at 3:30 p.m. in Courtroom 9B, Orange County Courthouse, Orlando, Florida. Time reserved 30 minutes. You have to bring your own interpreter. No telephonic appearance permitted without a court order. Done and ordered this 22nd day of August, signed by Judge Michael Dean. And they give the certificate of service to Brian C. Boone, Sarah K. Boone, and Joshua Martell. Okay, and so now we have gone over the motion to dispense with mediation, the letter from Sarah written 7/17, the judge's order granting the motion to dispense of mediation, and the notice of non-jury trial. So there is an order setting the hearing. We'll look at that next time. Financial affidavit, an order directing the Orange County Corrections to transport the defendant to the courthouse, and then 2 letters written from Sarah. So that will be next time. And hopefully you will enjoy looking at this little background recap while we are awaiting hearing the final ruling in family court today. I believe the court hearing is at 1 p.m. So we probably won't hear much of a recap until a little bit after, because it's supposed to last a couple hours. So sometime this afternoon, we'll be catching up with that. But in the meantime, enjoy this little recap. Keep it professional and respectful in the comments, and I will see you there. Thank you so much for watching.